Welcome back, everyone. I've changed the setup a little bit, and hopefully I'm talking loud enough. Anybody hear me in the back? Anybody hear me in the front? That is whoever wanted to hear me. Can you hear me? Yeah, thumbs up, thumbs up. Thank you very much. Appreciate that. All right. So today we talk about government transparency. Today we talk about government accountability. Have you ever seen an example of the government not shooting straight with you? For example, have you ever seen a press conference where obviously everything has gone terribly wrong, yet the politician takes the stance and says it was an enormous success? How do you prove otherwise? How do citizens get the information they need to make informed decisions, such as whether to boot that guy out of office or not? How do citizens learn the truth of matters? More importantly, we, the taxpayers, are funding these government agencies. We're funding the salaries of these politicians. We're funding state and local governments. Shouldn't we have accountability? Shouldn't we be able to know what's going on, to know the truth of the matter? That's the topic of today's lecture. Today's lecture is about government accountability. But as always in a law school lecture, I'm here to do more than just lament the problem. I am here to empower you. I'm here to show you how to do something about the fact that you or your client or society at large deserves to have government transparency, open government, government accountability, government providing access to meetings, to documents. How can this be done? That's what we're going to cover in today's lecture. But before we get to those nuts and bolts, you've always been kind to me, at least you have in the past, and you've allowed me to start every class with a prayer. I'd be remiss if I didn't do so again, because I love to do that, and I'm thankful for the fact that you tolerate me doing it. And before I get to the prayer, I just had a brief reflection for you, about the practice of law, about lawyers, about serving God. Now, surely you've heard the latest lawyer joke going around. It seems there's always another joke to be told. Usually it features a greedy lawyer or a selfish lawyer. Some might say that our great profession deserves to be the butt of such jokes. And yes, we've all met a lawyer or two whose behavior is less than exemplary. But what about the lawyer that wants to lead an exemplary life? What about the man or woman who wants to practice law, but who also wants to serve the Lord our God? Can it be done? I've asked myself that question more than once in my 25 years of practicing law. Can I be a lawyer, and also, can I be God's servant? I thought I had the right answer to that question. I really did. For so much of my legal career, I thought this was the right answer. On the one hand, I'd be a good and ethical lawyer. And on the other hand, I'd get involved with the church and I'd do good works. Yes, I had legal work to do. I would do it in an upright and ethical way. But I did not need to spend every waking minute practicing law. I would carve out plenty of time to serve the Lord too. That used to be my answer as to how I could be both a good lawyer and God's servant too. I worked hard toward this chosen answer of mine. I was getting better and better, carving out time for Christ and spending more and more time on him and his church. I became so busy implementing this answer of mine that I never stopped to ask myself whether there could have been a better answer. Do you see how there's a better answer? It's okay if you don't. For years and years as I did this, I couldn't see how there could be a better answer either. After all, I was being a good lawyer on the one hand, and then on the other hand, I was carving out more and more time from the practice of law to devote to my service to Christ. Surely that's a good answer to the dilemma of wanting to practice law and yet wanting to serve Christ. But what I suggest and what I ask you to consider is that there is a better answer. A better answer. If you stop and think about it. The problem with the answer that I had implemented for myself was that I saw the practice of law and the service of God as two separate and distinct things. I suggest, and I ask you to consider, that the better answer is to use your law practice as service to God. You see, I misunderstood. I thought there was the practice of law on the one hand and my acts of service to God on the other. My misguided goal had become to find a way to spend less time practicing law so that I could spend more time serving God. But now, in my humble opinion, and I suggest you consider this answer too, it's the very practice of law itself that can be a form of service to God. For the lawyer who wants to practice law and serve God, the good answer is to serve God after work. The better answer is to also serve God through your work. The good answer is to use more and more of your time outside of your law practice for doing God's work. The better answer is to also transform your law practice into God's work. The good answer is to not neglect the Lord our God when we are doing work other than practicing law. The better answer is to also glorify God through the practice of law. Am I off base? Am I off the rails? McGinley, have you got a bad idea here? Well, to help try to convince you that I don't have a bad idea, I confess that the idea is not my own. We look at so many saints who were lawyers. I could fill that whiteboard full of names of saints who were lawyers, and I suggest that they were not saints despite being lawyers, but because of it. I point out to you great saints like Jose Maria Escrivá and his wonderful movement, Opus Dei, who sought to encourage everyone in every profession to use their profession as service to the Lord. And of course, the legal profession need not be an exception. Another one of my saints, my hero, St. Maximilian Kolbe, and his movement, the MI, encouraged that every walk of life should join the MI. Every walk of life was an opportunity to serve the Lord. And I suggest to you that your legal career can be an act of service to God. And with that thought in mind, I begin this class with a prayer. And I pray as always in the name of the Father, and of the Son, and of the Holy Spirit. Amen. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. Hail Mary, full of grace, the Lord is with thee. Blessed art thou among women, and blessed is the fruit of thy womb, Jesus. Holy Mary, Mother of God, pray for us sinners, now and at the hour of our death. Amen. Dearest Mary, Mother of God, walk with us in this journey of life, and help we, the lawyers, to use our legal skills and our legal abilities as service to your Son, Jesus Christ. We ask this in his name, in the name of the Father, and of the Son, and the Holy Spirit. Amen. All right, thank you for allowing me to open this class with a prayer. And as I promised, this is a class about government transparency and government accountability. Here in Florida, as we study Florida's Constitution, we've got to ask ourselves, first and foremost, of what good is Florida's Constitution? Don't we already have sufficient federal law upon which to get this job done, to find the truth, to get access to government documents, to attend government meetings, to record those meetings, to have government transparency and accountability? We all know about FOIA, right? We all know about the Federal Freedom of Information Act. Maybe even some of us have made a FOIA request in our lives. Raise your hand if you've thank you, have made a FOIA request. The Federal Freedom of Information Act, if you're unfamiliar, you can find it in the U.S. Code at Chapter 5, Sections 552 et sequitur. Ooh, throwing some Latin there. Yeah, et sequitur. And what you find there is that it applies to federal executive branch government agencies. What you'll also find there, and in the binding case law precedent that interprets FOIA, is that FOIA, Freedom of Information Act, does not apply to state or local governments. Could a federal statute apply to state and local governments? Of course it could. You remember last week's lecture. You remember the supremacy clause of the federal Constitution. You remember preemption. You remember that it could. But when we look at FOIA at 5 U.S.C. Section 552, we do not see a means by which we can hold state and local governments accountable. That is why I wish to empower you and educate you about Florida's sunshine laws. It is Florida's sunshine laws that apply to Florida state and local governments. They require transparency. They require accountability if they are used correctly. And my point today is to educate you as to how to use them. Now, these government and the sunshine laws, they are amendments to Florida's Constitution. So the Constitution of the state of Florida has been amended to add these government accountability and these, if you will, sunshine laws, sunshine being slang, sunshine meaning, you can see it's out in the open, right? So we call these group of amendments to Florida's Constitution and the enabling statutes, most of which are found in Chapter 119 of the Florida statutes. We find them collectively referred to as Florida's sunshine laws. For example, on the big board, I've got Article 1, Section 24. This talks about access to public records and meetings. And it reminds us that every person has the right to inspect or copy any public record made or received. This section specifically includes legislative, executive, and judicial branches when it comes to inspecting and copying records. It also applies to counties, municipalities, indeed any state or local governmental entity within the state of Florida or created by Florida's Constitution or created by the Florida statutes would be subject to this kind of records request under Article 1, Section 24 and the Chapter 119 enabling statutes that implement how this gets done. There are three basic requirements of Florida's sunshine law. If government is to be in compliance, then these are the basics of what is required to be in compliance. First, meetings of public boards or commissions, they must be open to the public. Second, reasonable notice of such meetings must be given. And third, minutes of the meetings must be taken and properly recorded. Now, what do we mean by notice? We mean a publication. We mean a physical notice has to be provided to Florida citizenry. What do we mean by minutes of a meeting? Do we mean a verbatim transcript? No, we do not. What we mean, however, is that there must be an outline. There must be a recording in an outline form, in a physical, tangible form of the topics that were discussed and the major decisions that were made. You see under number 3 in the big board that minutes of meetings must be taken and properly recorded. What's meant by recorded? Each entity subject to a Florida sunshine law remains responsible for keeping these minutes in a record, which can then be shared with the public upon a proper request that meets the requirements of the enabling statutes in Florida Statutes Chapter 119. So that's the basic requirements of Florida's Sunshine Law. Now, at this point, we have roughly a state equivalent of FOIA, the Federal Freedom of Information Act. But as Ron Popeil would say, but wait, there's more. And indeed, I suggest that as I continue to empower you to use these sunshine laws, you're going to have to agree with me that a Floridian has a greater right of government accountability and transparency from the Floridian state and local governments than a U.S. citizen has from the federal government. I suggest that these sunshine laws are an example of our state constitution creating a greater right for state citizens, greater than provided by federal law. Indeed, when we interpret these government and the sunshine laws under Florida's constitution, the Supreme Court of Florida has made it clear that they will use an expansive reading, that the courts are obliged, says the Supreme Court of Florida, to err on the side of the citizen and to err on the side of public disclosure by the state or local government. There's plentiful case law. One site would be Caney versus Alachua County. This is the Supreme Court of Florida's 1973 decision, and the quote I take from that is that the sunshine laws, having been enacted for the public benefit, should be interpreted most favorably to the public, not to the government, to the public. Likewise, look at Palm Beach versus Gradison, another ruling from the Supreme Court of Florida, this one from 1974, saying that Florida's sunshine laws, quote, should be construed so as to frustrate all evasive devices. It's powerful language for you, the litigator, who's going to court trying to get government accountability, government transparency, the government to produce a document, the government to allow someone to attend a meeting, right? This is a good citation. Look at this one. Here's a 1983 decision from Florida Supreme Court. Florida's sunshine laws must be broadly construed to advance its remedial and protective purpose. Protective of who? The government? No. Protective of who? The county, the city, the state agency? No, no, no. Protective of the citizen. Protective of the Floridian. Protective of the Florida resident. Where does the sun shine? Every law has its limits. Every rule has its exceptions, right? So where can I find sunshine? What about the legislative branch of Florida government? What about the executive branch of Florida government? What about the judicial branch of Florida government? Let's take them one at a time, shall we? First, let's take a look at the legislative branch. Does the sun shine? You betcha. Take a look at Article 3. I know that as part of our syllabus, you are reading the entire text of Florida's Constitution. Perhaps by now you've gotten to Article 3. What does Article 3 talk about? It talks about our bicameral state legislature, right? The Florida Senate, the Florida House of Representatives, created and is given certain powers. It is the entity by which the police power of the state of Florida is implemented, correct? It is the entity by which our elected officials make and pass statutes, right? So Article 3 talks about the legislature. I hope you noticed this part of Article 3. This was part of those amendments that make up the Sunshine Law. Article 3, Section 4, quorum and procedure. The rules of procedure of each house, both the Florida House of Representatives and the Florida Senate, shall provide that all meetings of each house shall be open and noticed to the public. But wait, there's more. Also, all meetings that are prearranged gatherings between two or more members must be open and available to the public. How does that compare to the federal government? How does that compare to the federal Congress? Well, we know that federal Congress members meet in twos and threes behind closed doors all the time. Sometimes they even publicly call themselves a particular caucus, and they get together and they talk about the issues of the day, or perhaps they draft a bill, or perhaps they talk about how they might vote on a bill that's been drafted. All this is true not of the state of Florida's legislature, but of the federal legislature, the federal Congress. Not so for the Florida legislature, not so for the Florida Senate and the Florida House of Representatives. Look at the language of Article 3, Section 4. Any prearranged gathering between two or more members has to have what? You remember those basic requirements? There had to be public notice, right? There had to be minutes kept, right? The minutes had to be recorded, right? And the minutes had to be provided to a Florida resident who makes a technically correct request under the Chapter 119 Florida statutes requirements, right? So that's very different than what we see under the U.S. Constitution. Florida's legislature has the power to enact a Florida statute that carves out an exception to Florida's sunshine laws. But that power itself is limited in this way. You see it on the big board behind me. First, go back. First, that law passed by the Florida legislature that purports to carve out an exception to a sunshine law must specify on the face of that statute the public necessity for the exception. Oh, McGinley, there's always got to be a public necessity for a law. Yes, true. But here there is a textual requirement that the text of the law state what that public necessity is. Second, the exception carved out by this law, the exception may be no broader than necessary to accomplish what? To accomplish the stated necessity. And third, the single subject rule applies, by which I mean that this law enacted by the Florida legislature that purports to carve out an exception to the Sunshine Law may contain no other subject matter other than the exceptions and their enforcement. So the single subject rule applies. You as a litigator, think of how this might empower you. I take you back to our prerequisite class. I take you back to Con Law 1. There were plenty of times in the case law precedent that you studied in Con Law 1 that the litigators got creative, right? They're trying to meet whatever their burden was. And they came up, well, there's this public purpose for the law. There's this public necessity for the law. There's this rational relationship to this permissible public government objective. Remember how, as you read the case law precedent in your federal con law class, how this was very often true? Now take a look at Florida. Can the government's lawyer get creative, come up with extra reasons, come up with extra rationale, come up with additional public necessities? The answer is no. In order for this law that purports to enact an exception to public access and Florida's sunshine laws, the government's lawyer's hands are tied because the government's lawyer is limited to the purpose and public necessity for that exception that is stated in the text of that Florida statute. And the court's inquiry is limited to asking whether this exception is any broader than necessary to accomplish what? To accomplish the stated necessity as stated in the text of the law. So again, this is an example of a greater right that a Florida citizen has than a U.S. citizen does as a whole under federal statutes. Don't you agree? I hope so. So where does the sun shine? The first question we asked is whether the sun shines in the legislative branch. We'll make it red if it doesn't shine there. We'll make it green if that's where the sun shines. Does it shine? Survey says green. Yes. When it comes to the state legislature, indeed, the sun shines. But let's not stop there. Let's ask about the executive branch. When it comes to Florida's executive branch, is that a place where the sun don't shine? Let's take a look and find out. As to the executive branch and local government collegial bodies, McGinley, you're just talking about colleges? No. Understand the definition now. When we talk about a collegiate body in this context, we're talking about any group where decisions are made by taking a vote of its members, okay? So if you're in front of the city council and they have to vote yes or no, if you're in front of the Board of County Commissioners, you're in front of the Clemency Board or the governor, whatever group you might be in front of, if it's an example of the decision is made by taking a vote of that group, we're going to refer to that for sunshine law purposes as a collegial body. So don't just think colleges, okay? As to the executive branch and local government collegial bodies, any gathering of 2 or more members to discuss a matter that may foreseeably come before that body, that's considered a public meeting. So the definition of public meeting, as my friends in Boston might say, is wicked broad. Wicked, that's a Boston term, right? That's slang for really big, right? Yeah, that's very broad. And if it meets that very broad, very vast, very all-encompassing definition of a public meeting, then that public meeting must be noticed and open. We talked about those requirements. You remember those basic requirements, right? Advance notice in tangible form to the relevant citizenry. And then we keep minutes. It's not a verbatim transcript, but it certainly reflects all the issues raised and decisions made. And then we record those minutes at the government's expense and keep that record for posterity so that whenever a Floridian makes a proper request, it must be provided to that Floridian. In general, only 2 exceptions exist to these sunshine laws and their application to Florida's executive branch. The first exception is called the use of staff exception. And the second exception is the fact-finding exception. Both of these exemptions ultimately turn on whether there was actual or apparent decision-making authority. So if there's an absence of actual authority, but yet there's apparent authority, then you're not going to meet either exception. Let's take each exception and define it just a little bit better, shall we? Use of staff exception. Exception to sunshine in the executive branch. Imagine, if you will, that the executive branch officer is typing something up, writing the report. Perhaps the executive branch officer does her or his own typing, or perhaps the executive branch officer might have some clerical assistance, right? Someone might do the typing for him or her. Perhaps she or he might be the type that hangs over the typist, lurking behind. This is a common mistake for first-year associates as they go to work at a big firm. They're lurking behind the paralegal. They're lurking behind the legal assistant who's doing the typing. Believe you me, if you make that mistake, you'll learn quick that the paralegal or legal assistant is quite sick of you watching every key press. But whether the executive branch officer is lurking or whether just talking with the typist, there's going to be some discussion, and it might get substantive. We might need to rephrase this from the first draft and phrase it that way in the second draft. We might have to add this to the third draft, or flesh this out better in the fourth draft. The use of staff exception means that you, as a citizen of the state of Florida, don't get to be lurking over those conversations. So we at least let the executive branch members work semi-privately with their staff when it comes to these clerical tasks. And that's about as broad as this particular exception to sunshine for the executive branch gets. Don't read too much into it. If you've got to read it one way or the other, you remember the case law precedent that we'd summarized on the big board. We're going to err in favor of the citizenry. We're going to err in favor of ruling against the government, right? We're going to interpret the sunshine laws in such a way as to foil any evasive attempts to be less transparent by the government or to hide government secrets, okay? The second exception we talk about here when it comes to exceptions for sunshine regarding Florida's executive branch is the fact-finding exception. And this is where you've got to watch out for the possibility of apparent decision-making authority. There are some executives or collegial bodies that might send out an individual or send out a group to do some fact-finding, to do some investigating. Assuming that there is no apparent or actual decision-making authority, then that group and its work would fall under the fact-finding exception. But if you've misled the Florida citizenry, if you haven't been clear with Florida's population, and it seems that this fact-finding group has some apparent authority, then despite the lack of actual authority, that fact-finding group will not qualify for this particular exception for the executive branch. So this is a factual inquiry. You as the litigator, you're going to do what? Discovery. You're going to take depositions. You're going to talk to witnesses. You're going to do some interrogatories. You're going to get some sworn statements and affidavits. Can you make a case for apparent authority? Even if the government is insisting, oh, no real authority there. No, that was just fact-finding. No. If you can, then you might prevail. Yes, question?
So, what does that apparent authority look like? Like, if they send out a group to investigate X, Y, Z, and they're supposed to send back their recommendations or their findings, something along those lines, is that actual authority? Because their decision isn't final, but they're still giving this recommendations.
Right. Now, whether or not, your question is, what does apparent authority look like? And you gave me some scenarios. One scenario you gave me was, well, what if they're going to make some recommendations? Bada bing, bada boom. Now you've got at least apparent decision-making authority. You probably have a case of actual authority because recommendations, that deserves government transparency. That deserves input by Florida citizens. That deserves sunshine under Florida sunshine laws. So now it's going to be a factual question as to whether or not there was apparent decision-making authority. The burden's going to be on the government to make it absolutely clear how this group functions and what this group does so as to try to qualify for the fact-finding exception. So there can be a myriad of flaws that you might prove as the litigator and overcome an allegation of the fact-finding exception. One of those, as you pointed out, of what if the fact finders get to focus on this and eliminate that? That's a decision. That's apparent authority, if not actual authority. That's going to question whether or not they qualify under the fact-finding exception. What if this group decides what to investigate and what not to investigate? Again, that's a decision. I would argue that's actual authority. It's probably at least apparent authority. To the extent that decisions are getting made, you're going to have a strong case for apparent decision-making authority and perhaps even a case for actual authority. So I hope that answers the question. Did I answer the question well enough as to what a failure to meet the fact-finding exception would look like?
Yes, I mean, I still have these ideas, but I
Yeah, tell me some more of those ideas. You have an example? I can answer it perhaps.
Well, it's just like, at what mean, like you said, it's gonna come down to the litigation determining what the body, at what point
True,
their
true.
recommendations, their findings become authoritative, and at what point are they just a reporting of facts?
Well, I hear what you're saying, and you're using the phrase authoritative, but that's not what we're looking for when we try to see whether the fact-finding exception is met. Even if it's a preliminary decision, even if it's not a final decision, we're going to interpret Florida's sunshine laws to thwart all evasive attempts. So we're going to say sunshine applies there. So don't think that the legal standard was this the final decision maker? And if it's not, then fact-finding exception exists. No. That's an incorrect statement of the law. The correct statement of the law is, was there either actual or apparent decision-making authority by this group that allegedly was a fact-finding group? That's the legal standard to apply. You have a question? Yeah. How dare you take your knowledge from another class and apply it here? I'm just kidding. It's a great idea. Go ahead.
If they have, reasonable, that these people have the authority to make these decisions, then they're going to think that, okay, they have actual authority, which they have apparent authority because they think they have actual authority.
Okay, I like your comment. I would clarify it in one way. The inquiry is not whether the government-appointed individuals that allegedly made up only a fact-finding board think they have authority or not. The question is whether Florida's citizens think they have authority. That's the focus of the legal standard. So you look at the announcement, you look at how it was published, you look at the words of the commissioners at their collegiate body meeting when they sent out this group, you look at what they did, you look at how they did it, and you ask yourself what the citizen would think. Would the Florida citizen or Florida resident think that there's decision-making authority here? And if the answer is yes, then sunshine applies. So we're not trying to read the minds of the members of the alleged fact-finding group. Instead, we're turning to the residents of Florida and we're saying, what do you think was going on here? That's the inquiry we use to determine whether or not there was actual or apparent decision-making authority. And why is that the inquiry? Because we're erring on the side of the Floridian. We're erring on the side of the people versus the government. We want, under a sunshine law, any doubts to go in favor of disclosure, any doubts to go against government secrecy, any doubts to go in favor of government accountability and transparency, any doubts to go against government secrecy and government obfuscation. So that's what we're talking about here. These are two possible exceptions, very limited, very hard to qualify for, very narrow exceptions to government in the sunshine for Florida's executive branch. So then, to wrap up our executive branch summary, does the sun shine on Florida's executive branch? Let's make it red if it does not shine. Let's make it green if it does shine. Survey says green, right? Yes. So the sun does shine in Florida's executive branch. We got another branch to talk about. It's the branch that you and I are officers of. It's the judicial branch, right? Does government shine upon Florida's judicial branch? Let's look at Florida's sunshine laws as they apply to the judicial branch. We know from Article 1, Section 24, which we already talked about, that when it comes to documents and access to public records and meetings, every person has a right to inspect or copy any public record made or received. So that's not only made, that's also received. You file a complaint with the judicial branch, and the other side eventually files an answer. Both sides may file motions. The side that loses might file an appellate brief. Are all these things under seal? Nobody gets to read them? Quite the contrary. These are not documents that were created by the judicial branch, but they were certainly received by the judicial branch, were they not? So we don't care who made the document. The question is, who has the document? And if the government has it, then it's public. So when you file something with the judicial branch as a lawyer, unless you qualify for an exception, unless you have the right to redact something on it, unless you can get an order sealing it for a potential short period of time, unless you somehow qualify for one of these exceptions, which are disfavored, all these filings of yours and your opposing counsel and every other lawyer and every other opposing counsel become public. This section specifically includes the judicial branch, as I underlined on the big board there. So, to summarize, and we have many, many details to come, does Florida's Sunshine Law shine on Florida's judicial branch? Let's make it red if it does not. Let's make it green if it does. Survey says green. Green. So we have a powerful means of holding all of Florida's state and local government activity accountable and in the sunshine and physically available to attend and inspect and to see and to copy under Florida's sunshine laws. But of course, every rule has its exceptions. Every law has its limits. Likewise, the sunshine laws have some very, very limited exceptions that we've already talked about, but they also have some limits because of the concept of separation of powers. In your federal constitutional law class, you certainly encountered the idea of separation of powers. Here you are encountering it again in your subnational constitutional law class here under Florida's Constitution. First, I would point out the legislative branch and a limitation caused by separation of powers. Florida's legislature is authorized to enforce access and exceptions via the legislature's own rules. Now, that's an important distinction because the courts will not become involved in interpreting and enforcing the internal activities of the legislature. We're going to study in great detail in this class how laws are made. We're going to study lawmaking and its limits. Part of our studies will talk about the procedural ways in which Florida laws are made as to where a legislature meets, what day it goes into session, how long a thing stays in committee, whether a thing gets called up for vote, when the legislature ends, when a special session can be called. These things are subject to constitutional requirements, many of which empower Florida's legislature to make that decision. By separation of powers, we're not going to have standing to go into court to argue that the legislature should enact a different rule of procedure for convening the legislature, or that the legislature should be enjoined in a court of law from abiding by the rules and regulations of the legislature, because to do so would create a separation of powers problem. The courts are not going to become involved in interpreting and enforcing the internal activities of Florida's legislature. That's a separation of powers limitation when we talk about the legislative branch. But likewise, we see some separation of powers limitations when we talk about the executive branch. Florida's Sunshine Law does not apply to those powers of the governor and the governor's cabinet that derive from Florida's Constitution. What am I talking about there? Well, one, for example, would be the governor and his cabinet or her cabinet are exempt from Florida's Sunshine Law in dispensing pardons and other forms of clemency authorized by Article 4, Section 8A of Florida's Constitution. You're on your way to reading all of Florida's Constitution. Perhaps you've gotten as far as Article 4. What does Article 4 talk about? Article 4 creates Florida's executive branch. and gives the executive branch certain powers, authority, rights, responsibilities, and duties. Sometimes our state constitution talks in broad terms. Other times, our state constitution sounds like a micromanager because it is spelling out with great specificity about how a thing is to be done. One of our canons of construction, or rules of interpretation, if you will, of the plain text of Florida's Constitution is this. When Florida's Constitution spells out in great detail how a thing is to be done, then doing that thing in a way that contradicts the great detail of the plain text of Florida's Constitution is unconstitutional. So when we see parts of Florida's state constitution that read like a statute, that seem to have no need for an enabling statute, that spell out in great detail what's to be done and how it's to be done, then doing that task in another way is unconstitutional. I point that out because my example talks about pardons and clemency. If you've read Article 4, Section 8, you can see how it spells out and micromanages in great detail right there in the text of Florida's Constitution exactly who's on the clemency board, when the clemency board meets, how the clemency board makes its decision. You might argue, well, on top of that, we should add the sunshine laws on top. But to add the sunshine laws on top would mean that the plain text of Florida's Constitution spells out exactly how to do a thing, and you're saying we should do it in a different way. Remember the canon of construction. Remember the rule of interpretation for Florida's Constitution. When Florida's Constitution spells out exactly how to do a thing, then doing it in another way is unconstitutional. For that reason, we have a separation of powers issue for those particular parts of Article 4, the executive branch article of Florida's Constitution. When you see something there that spells out exactly how it's done, you don't throw the sunshine law on top because of this separation of powers issue. So just like you saw some separation of powers limitations in the legislative, you also saw them in the executive. What about the judicial? Yes, you do see some limitations upon Florida's sunshine laws based on separation of powers when it comes to the judicial branch. One example, in Article 5 of our Constitution of the State of Florida spells out Florida's judicial branch. How do you get to be a judge in Florida? One way is to be nominated by the Judicial Nominating Commission. How do they work? Well, Article 5 spells out how they work. You remember the canon of construction. You remember the rule of interpretation of the plain text of Florida's Constitution. When Florida's Constitution spells out exactly how to do a thing, then doing that thing in any other way is unconstitutional under Florida's Constitution. So the Judicial Nominating Commission, can I get the records? Can I get their notes? Can I attend their meeting? No, I can't get their records. No, I can't get their notes. No, I can't attend the meeting despite Florida's sunshine laws. Because the way that Judicial Nominating Commission operates is spelled out in great detail in Article 5, and we don't add the sunshine laws on top of that, because if we did, that would be a separation of powers issue. So do you see how the separation of powers, which is its own chapter in our text, we'll be returning to separation of powers later in the semester. But for now, do you see how it even invades and applies when we're talking about the sunshine law? There's 3 examples of that. So the question then that I ask you is this: how well do you understand Florida's sunshine law? Let's do this. Let's take our first break. Let's take a 10-minute break, if you will. When you come back, let's do a little Q&A. Let's do a little questions and answers. Let me throw up some hypothetical factual scenarios, and let me ask you what the right answer is under Florida's sunshine law. Remember, I'm here to empower you. I want you to be able to use these laws for the benefit of your clients. So you might get it wrong here and now, but that's better than getting it wrong after you're licensed to practice law and you're arguing in front of a judge, right? So let's practice in the here and now. Let's take that 10-minute break. And when we come back, let's put on our thinking caps and see if we know the right answer. I'll see you in 10.
I didn't realize that.
As we make our way back from the break, I just wanted to point out, I sent everybody an email with some housekeeping on there. I know under our syllabus, we've got that lead counsel obligation, so hopefully the email answers all those questions. I prefer to send the housekeeping things like that out via email than take up your time in a lecture. There's plenty of substance in this class, so I want to save time for the substance. Ever been to a restaurant in Winter Park called the Coop? C-O-O-P, the Coop. Have you been there in Winter Park? Yeah, fun little restaurant. Coop is a reference to chicken coop. For those of us who've been there know that. Those of us who haven't, maybe you don't. But I was there with Bernadette, my wife, once, and a woman comes up to me, and I recognize her from somewhere, from class, former student. And she's Professor McGinley, she calls me. I just wanted to thank you. I took the Florida bar exam, this was a couple of years ago, and the Florida con law essay, which almost invariably is an essay, and it's on the Florida bar, had to do with the sunshine laws. And my class, as always, covered that. And your current other professor, this was years ago, so this is not, we're not talking about him, we're not talking about Jason, but there was a different professor then, and that professor didn't cover the sunshine laws. So she was thrilled. She felt she had the edge. She had learned about the sunshine laws in her Florida con law class when others hadn't, and she talked to some folks who just didn't have a clue how to answer the question. So that made me feel good. So it's an important topic, not only for litigation, but if you're going to pass the Florida bar, who knows, could be on there. Welcome back, everybody. Before the break began, I left you with a cliffhanger because that's how great drama goes, right? This is not only a lecture, it's a show. I got to have some drama. And I had a cliffhanger. The cliffhanger was this. The unanswered question was this. How well do you understand Florida's sunshine law? How well? Let's find out, shall we? All right, let's consider this. Some members of the Florida House of Representatives are sad. They're sad because their favorite candidate for Florida's governor wasn't the person that won the election for governor. They're very sad about this. So they create the House Impeachment Caucus. And the members of the Florida legislature who they invite to be on the House Impeachment Caucus, they meet privately to discuss how their caucus is going to vote to discredit and ultimately impeach Florida's undeserving governor, in their opinion. Any constitutional infirmity under Florida's Constitution? Anybody see a sunshine law violation? Anyone think, oh, that's cool. Yeah, no, that's okay under Florida's Constitution? Let's go with a show of hands. How many think, oh, that's cool, that's okay under Florida's Constitution? Go ahead and raise your hand. I don't see any hands. I guess I started with the softball, didn't I? Who will raise their hand and say, I see a sunshine law violation? If your hand is up, then you are correct. Indeed, this would be a sunshine law violation under Florida's Constitution. It would be unconstitutional here. Now, unlike the federal Constitution, this meeting, prearranged, of members of the Florida legislature, it's got to be public. It had to meet those three basic requirements. Remember those? We had to give tangible notice to the public. We had to keep minutes, and we had to record those minutes. So a group like a federal caucus, and there are several, right? Certainly you've seen in the news when we talk about federal government, when we talk about the federal Congress, there certainly are caucuses. They get together, they meet privately. They decide how to draft legislation. They decide whether or not to oppose certain legislation, right? That happens all the time under the federal Constitution and in Washington, D.C. under our federal legislature. Because it's not unconstitutional under the federal Constitution. It's not impermissible for the federal legislature. Compare that now to our state legislature. Compare it to the Florida Senate and the Florida House of Representatives. There, the sunshine law would prevent such behavior, would make such behavior a sunshine law violation, would make that unconstitutional, right? So a group like a federal caucus could not operate in Florida's legislature in the same way that we see them operating quite regularly, these caucuses in the federal legislature, right? So when this class began, I put forth a premise I said perhaps the state constitution can be like a laboratory of the democracy insofar as the state constitution cannot deny a Florida resident anything less than the full panoply of federal constitutional rights, regardless of the source of those federal human rights. But while recognizing and granting that full panoply of federal rights, can experiment with granting a Floridian even greater rights than Americans as a whole. From that perspective, this could be such an example, could it not? We're free from these backdoor deals, or at least, hopefully, more free from such backdoor deals. As you read the chapter, you probably read about the pork chop gang, who here is and will admit to being, a card-carrying member of the pork chop gang. Come on. If you're in the pork chop gang, let's admit it. No, the pork chop gang is a historical reference. It was a real thing. You read about it in my chapter there. It was part of the motivation for Florida's sunshine laws because it was really happening. It was way back when. It was a group of Democrats, and they would meet at a fish camp. I'm not making this up, okay? These were panhandle Democrats long, long ago. You've got the exact date in the book. And they'd all meet at the fish camp before Florida's legislature went into session. And what did they do at the fish camp? Well, they drank quite a bit, according to the reporter who reported about this. They played a lot of cards, according to the reporter who reported about this. But most of all, they decided what legislation would get called up for a vote and what wouldn't. They decide what bills they would draft and call up for a vote. The legislative meetings then, once the legislature of Florida finally went into session, were more like a dog and pony show. They had been pre-orchestrated. The fish camp was the real place where laws were made and decisions were made. The legislature then was where the formality happened and the votes were cast, but all the real decisions were made over whiskey and poker at the fish camp. Could the government do that? Back then it could, because we didn't have Florida's Sunshine Law. Part of the impetus, part of the reason for Florida's Sunshine Law was the pork chop gang, as that reporter reports and as Florida's history reflects. It's written in better detail in my textbook there. I hope you enjoyed reading about it as much as I enjoyed writing it. But so we can't operate the same way in the Florida legislature that the federal legislature operates. But perhaps that's a good thing. Perhaps that means there are greater rights for Floridians. Perhaps that means there are fewer backdoor deals, right? All right, here's an interesting one. Another question for you. You nailed the last one. Let's see if you can get this one right. We've got an aggressive reporter. We'll call him Dan. News reporter Dan sends an unsolicited email to a Florida senator, an elected member of the Florida Senate. We'll give this fictitious person a fictitious name. We'll call him I Am Framed. So Dan sends an unsolicited email to Senator I Am Framed of the Florida Senate, and that email contains a very embarrassing attachment. Go ahead, let your imagination run wild. Oh, you do not want to be in possession of this particular attachment, okay? Then reporter Dan shows up at Florida Senator I Am Framed's office with the cameras rolling, demanding to see Framed's emails. Man, time to hit delete if you're Senator I Am Framed. Or is it? That's my question. We know Senator Framed would be embarrassed to possess the attachment. Might even be the death of Senator Framed's political career. Must Senator Framed make the embarrassing attachment public? Who says yes? Raise your hand. One person got it right. In a room of 56, 58, what are we? Come on, raise your hand if you think Senator Framed is going to have to produce There's another person. Now we've got 2 people that got it right. Anyone else want to raise their hand and get the answer right? There's 3, there's 4 people who are right, 5 people, 6 people. Come on, put the hands up. All right. Yes. Florida's Sunshine Law applies to what? Just the things that the government creates? No. Anything it's in possession of. Anything it's possession of. What if it's something they don't want to be in possession of? Well, you're free to explain that. I didn't ask for this email. I didn't want this email. I didn't even open this attachment. I would never possess this thing. You can explain that, Mr. Government Official, but you can't hide the documents from us. The answer is almost certainly yes. It's irrelevant under Florida's Sunshine Law. I see there's 2 questions. I'm not going to miss either one of them. It's irrelevant under Florida's Sunshine Law that a document in the government's possession was not made by the government. It's irrelevant that it's not desired by the government. If it comes into the possession of the Florida government or its agents and it doesn't meet a sunshine exception, then it's got to be made public upon a proper request. I've got 2 hands up. I'm not sure who came first. I'll just take the 3 hands. I'll take you first because you're closer to me.
The reason that I felt like that was tricky was because I didn't think it's a proper request for you to show up with the cameras rolling to show it to me right now.
So you had an issue with the timing.
Yeah. I feel
Okay,
like-
and I might give you that. There would be a timing issue. Perhaps Senator Ian framed could require that the formalities of Chapter 119 be met, proper time and things. I might give you that. But ultimately, Ian framed can't hit delete. Ultimately, the government's not going to succeed in hiding this or failing to produce this. They're going to have to make it public. They're going to have to share it. They can feel free to offer whatever explanations they want, but they can't hit delete. They can't hide it. They can't refuse to share it. They can't keep it secret. They can't deny public access. Another hand in the back.
Yeah, so I thought that it was no because under Florida Statute 119.011 subsection 12, it has to do with information that is made or received pursuant to law or ordinance in connection with the transaction of official business.
Yeah.
If this was just an attachment that was sent for no good reason, it wasn't asked for by I am framed, then it wouldn't be in connection to a transaction of official business, so it shouldn't have to be disclosed because it's personal. It's not, doesn't have anything to do with his senator position.
I like your citation to Florida Statutes Chapter 119 and the specific subsection therein. I'm familiar with that law, and I'm familiar with the case law that interprets it. And to that extent, I have bad news for you. This scenario would not meet an exception. Now, one thing you point out, and there's only so much room on my slide here to fill it with words, is that I didn't note that this was his official email account. That might make a difference insofar as whether or not it qualifies for disclosure. Now, I say that with caution, because if it's the government official that fails to keep the government officials' private email and public emails separate, then all the government officials' private emails are now subject to the Sunshine Law. The impetus is upon the government official to create separate accounts and to maintain those accounts as separate. So I'll note that I didn't write in his very already wordy slide the fact that this was his official email address. That may or may not have made a difference. The mere fact that he put it in or kept it in or received it in his personal email is not dispositive, because the impetus is upon the Florida government official to keep and maintain that separate email account. Likewise, there's got to be backups of it, and it's got to be stored. So, for example, I don't mean to get too political here. Hypothetically, if we created a mail server and kept it in the basement, that would be a violation of Florida's sunshine laws, Now, maybe in the federal government, you can run a mail server in your basement and we don't lock her up for that. But under the Florida sunshine laws, that's a clear sunshine violation because you fail to maintain and you fail to keep the email separate from your personal, and you fail to keep it in such a way that the public record request could be honored. Now, the other part of your statute cite that you cited to me has far less strength and power in practice than it seems to imply within the words of the statute. When you read me the words of the statute, you said it had to be part of official business. And there is a plethora of case law where the government tries to say, well, this part of the email was government business on the government email server, but this part wasn't. Or, oh, the official made a mistake and sent and received personal email within the public server. And the case law is always the same. Too bad, so sad, government. We're going to err on the side of disclosure. We're going to err on the side of the citizen. We're going to disclose that email. Indeed, if you've ever exchanged email correspondence with a state of Florida agency or official, you'll see in their signature line some boilerplate text that warns you, whatever you send me is going to be part of the public record and can be seen by the public upon request. So the government can't split hairs and say, all right, we've got 100 emails here. These 80 had to do with government business. These 20 didn't. The burden's going to be on the government. And more often than not, the government's going to lose. It doesn't matter that the government didn't want that email. It doesn't matter that the government discouraged that email. It doesn't matter that the government said, don't email me this. If they've got it in their possession, and they have it in their possession because they're the government, that's enough to meet the citizen's burden. So the citizen isn't also burdened to say, well, this was a state senator and that particular topic has to be part of something they were debating. No, that's not part of the citizen's burden. It's not part of the citizen's burden to say, well, this government agency is in charge of this kind of thing and this email has to do with that kind of thing. No, it's not under Florida sunshine law part of the citizen's burden to prove these things. We're going to err on the side of the citizen. We're going to err on the side of disclosure. To that extent, we may have greater rights as a Florida citizen than we do as a U.S. citizen as a whole. But that was the intent of Florida's sunshine laws. So part of the language you quoted to me lacks bite because the case law precedent says it lacks bite. Because what we're trying to do, where's my case law, is things like this. Having been enacted for the public benefit, we should interpret it most favorably to the public. So yeah, that language you quoted to me could easily be interpreted favorably to the government, but we're not going to do that. We're going to interpret it favorably to the public. The language you quoted to me, we have to construe it so as to frustrate all evasive devices. On its face, that language you quoted to me could be a broad exception where the government could pick and choose and say, well, this is not something that gets disclosed. I was watching the news the other day, and there was a son of someone who died in the 9/11 attacks who wants more government information about a particular nation and their possible involvement in the 9/11 attacks. And he complains that under federal FOIA law, this information is kept from him, so he can't have it. And when he asks why it's kept from him, the reason it's kept from him is also a government secret. So he can't have the documents, and he can't know why he can't have the documents under federal law. This was the complaint made on the news by a son of a father who died in the 9/11 attacks and is leading a group that wants to know whether this particular nation that they have in their sights was involved with those attacks. That's an example of FOIA. That's an example of federal law. That's not an example of Florida sunshine law. In Florida sunshine law, the government doesn't have such broad authority to say, well, that's not part of the sunshine law. Because of cases like this, Florida sunshine law has to be broadly construed to advance its remedial and protective purpose. Protect who? Protect the state of Florida? No. Protect the Florida county? No. Protect the Florida city? No. Protect the Florida agency? No. Protect the Florida man. Protect the Florida woman. Protect the Florida child. Protect the Florida resident. That's who we broadly construe to advance the remedial and protective purpose of Florida's sunshine laws. So yeah, if you go to the plain text of these sunshine laws, it looks pretty good for the government. After all, they wrote them. But when you go to the case law precedent, you don't see it interpreted broadly in favor of the government. You don't. These are powerful means by which we can demand accountability and transparency from Florida's state government. So the answer then is almost certainly yes. And I missed a question. Was it yours, sir?
I had the exact same question.
Yeah, the exact same question. So I answered it?
Yeah.
And did I answer your question?
Yeah.
Okay. Any unanswered questions? Yes.
The need for, I guess, the need for it to be official business, you're saying that's a weak argument. Does that only pertain to production of documents, or it also relates to meetings too?
Yeah, it's weak on all counts.
So like.
Never will you be in court and the judge will say to you, attorney for the citizen, prove that that was official business. Never will a judge ask you that. Why? Because the case law is so abundantly clear that that is not the citizen's burden, and equally abundantly clear that that is not a valid defense of the government. It doesn't matter how the government got in possession of these documents. If they're in possession and they're the state of Florida and they're the Florida government, they're going to have to produce them in a sunshine law unless they meet one of those very narrow exceptions that we talked about. But one of those exceptions isn't to say, oh, that wasn't government business. No. Or I'm the water management district. This didn't have to do with water. Oh, that's very nice to hear, says the judge. Now turn them over and pay his attorney fee. Thanks for coming today. Give me an injunction to sign. Let's schedule another hearing from 10 days, just in case my injunction is not enforced. I've got the sheriffs and their guns who will enforce it for you. But I hope you'll honor it voluntarily. Thank you, Mr. Government, and thank you for your opinion. That's literally how it could go, because these sunshine laws are that powerful. It's not a government defense to say, well, that particular email in the government account received by the government official from the citizen, that's not the kind of thing we're going to share with the citizen. Maybe that works under FOIA, but definitely does not work under Florida's sunshine law. Yes, question?
So there's no real limitation as to what people can request, but they do charge you money in order to recover the records, right?
Oh, yeah. You'll see in those enabling statutes in Chapter 119 that there are requirements that you may have to fill out a form, you may have to prepay for the cost of these records. Yes. And these are burdens. Sometimes these are obstacles. It's true. But what we'll talk about in another big slide example in a minute is sometimes, as I alluded to with my hypothetical answer a minute ago, sometimes the government can be forced to pay the citizens' attorney fees and costs. So, yeah, it's true. You might have to pay 10 cents, 25 cents a page, whatever the going rate might be. And for some of our fellow Floridians who are living paycheck to paycheck, that can be an enormous burden. I don't discredit that. But ultimately, once that is met and those reasonable costs are paid, then the Floridian has greater access to government records of Florida's state and local governments than an American does as a whole. So, and you're right about that. I do acknowledge that can be a burden. For the wealthy, a small burden. For the not so wealthy, a big burden. Yeah. Question?
Just real quick, would an element of criminality do anything to delay or stop the release of this information?
So your question is whether criminality would what now?
Whether it would either stop or delay the release of the information. So the attachment that this senator received.
Okay.
Either the attachment itself was criminal or
Interesting.
had some sort of criminal element to it, displayed some sort of crime. And he obviously turned it into the police and went through all the right steps.
Yeah.
So that then protected from being Or because it was in the government's possession at some point, they then have to.
I think the correct answer is that it would have to be released and that the government would be able to cite to the law that makes it a criminal offense, and that would put a limitation upon the release. So, for example, I don't know what you're thinking that hypothetical reporter Dan sent to hypothetical Florida Senator I.M. Frame, but maybe it was something that's just illegal to possess. That certainly is an argument to make it less than broadly public to the world, but that's not going to be sufficient to say, therefore I produce it to no one. So we're going to have to carve out some sort of reasonable standard there, such as, and we'll cover probably in our next class, the new NEU case law decision. Perhaps you read that far in the book already. You saw where they had to work out a reasonable way to both comply with the Sunshine Law and make things less than fully transparent for now and then fully transparent later. So that real life case is somewhat like the hypothetical you're giving me. And you give me a hard one. I respect that. But I would suspect that case laws such as new NEU that you read in the book there would be the binding precedent that would apply to such a situation. So another question? All right. So the answer here when we come to reporter Dan and Florida Senator I.M. Frame is almost certainly yes, because it's irrelevant under Florida Sunshine Law that a document is in the government's possession, that it wasn't made by the government, that's not desired by the government. And as we fleshed out through the questionnaires here, maybe it's far afield from what the government was doing. Right? For example, you read perhaps NCAA versus AP. We'll talk about that in greater detail, either at the end of this class or the beginning of our next class. But you saw there how the Florida State University was in the business of educating students, right? That was their job. And then the lawyers were in the business of advising the agency. And then the NCAA was in the business of enforcing sports rules and regulations. But yet those documents had to be turned over. You couldn't hear Florida State University saying, well, that wasn't within our scope of authority. That's not our business. That's not our government purpose. That's not what we do for a living. Who cares? You're part of Florida government and you've got access to those documents. Hand them over. We're going to interpret Florida Sunshine Law that broadly, very broadly. NCAA versus AP is a great example of that. We'll talk about that case in greater detail, but right now we're still playing with our hypotheticals. So let's put another one on the big board, shall we? This is great because it's helping us back and forth, helping us to understand these laws. Let's take a look at another one. This question involves Matthew, Mark, and Luke. No, not that Matthew, Mark, and Luke. These are 3 lifelong friends and current members of the Vero Beach City Council. And there's something else. They're taco lovers. Who here loves tacos? Love tacos. You know, if there was some sort of worldwide catastrophe and the only left to eat on the planet was tacos, it'd probably take me like a week or 2 to even notice the other foods were gone. Love tacos. I love tacos. I don't know about you. I love tacos. So do Matthew, Mark, and Luke in my hypothetical. And they've been lifelong friends. They weren't friends or didn't get acquainted because they are on the Vero Beach City Council. They've been lifelong friends. And for years now, they've been going to Taco Bell on Taco Tuesday because that's what good friends who love tacos do on Tuesday, right? So after Monday's council meeting, they agree to meet at Taco Bell for Taco Tuesday before Tuesday's council meeting begins. That's what they've always done. And that's what they do. Have they violated Florida's sunshine laws? If you think this is a violation of Florida's sunshine laws, go ahead and raise your hand. Raise your hand. Come on, raise your hand. That's a hint. Raise your hand. Yeah, raise your hand. Raise your hand if you think this is a violation of Florida's sunshine law. Raise your hand. You're correct. Look at all those hands up there. Look at how correct you are. Proud of you people. Proud of you people. All right. Yes, this hypothetical is a violation of Florida's sunshine law. Matthew, Mark, and Luke are meeting at Taco Bell during a break between council meetings. What? During a break between council meetings, McGinley, you're off the rails on that crazy train. No, I'm not. We're going to interpret the Sunshine Law in what way? To thwart all evasive devices. Is one reasonable interpretation of these facts that this is a break between Monday and Tuesday's meetings? Yeah, so we're going to do it because that's going to get us to disclosure. That's going to get us to open government. That's going to get us to sunshine. You've got a question?
Yeah, so my problem is nothing in the fact that are alluded to the fact that they were discussing any of the matters that were, that had to do with the council meeting. So if it doesn't say, well, they were discussing matters at the council meeting, how are we supposed to, because that's inserting facts into the fact pattern. We could talk for all of law school not to do it.
Okay, I hear you. You don't want to avoid those law school question and answer prompts that you've been taught. I respect that. And I come to this material from the perspective of a practitioner. You know, I come here on Wednesday nights and play professor, but 60 hours a week I'm practicing law and representing real clients. And I'm telling you here, when it comes to interpreting Florida's Sunshine Law, you're going to interpret it in the way that favors disclosure. You're going to interpret it in a way that avoids the government hiding things. You're going to interpret it in a way, and I'm talking about the courts, talking about the judges, that lead to disclosure. And here you've got a council meeting on Monday. You've got a council meeting on Tuesday. After Monday's over and before Tuesday begins, these three council members are going to be together. Why are they going to be together? Because as they discussed at Monday's meeting, they're going to get together. When are they going to get together? Before Tuesday's meeting starts. Anybody smell a rat? Well, you don't have to smell a rat. If you're the government, you could argue, well, it's just all innocent. They've been lifelong friends. This is what they've always done. Well, sure. And then you carve out through the case law a new exception to Florida's Sunshine Law. Is that the goal of the case law? Is the goal of the case law to create more and more and more exceptions? Is the goal of Florida's courts to scale back the Sunshine Law? Is the goal of Florida's Sunshine Laws to make everything a secret, keep everything away from the Florida citizen? No, the goal's the opposite. The goal's the opposite. So are there two ways to interpret these facts? Yeah. Which way does the law require, as a matter of law, these facts to be interpreted? We're required, as a matter of law, to interpret them in the light most favorable to public disclosure, which is easy to do here. Three council members, at the end of one council meeting, decided to get together before the beginning of the next council meeting. You can smell a rat there. And if you can smell a rat, then you do smell a rat. I've got three questions. I believe you were first.
So is this more related to the time frame because they met the day of the meeting? You know, is that to say that if two or more members are getting together to have like Friday barbecue is nowhere near the meeting? Is that also disclosed? There's like Christmas parties or all of them together, that all has to be disclosed?
And you've heard the question. The question is it all about the timing? And certainly the timing makes it more incriminating under this fact pattern, does it not? And on Florida bar exam, real question that was given to people taking the Florida bar exam, you mentioned in your hypothetical, what about a party? And in that Florida bar exam, three people happen to be at a party. So yeah, part of it's the timing, but part of it is not. What we expect is that when there's a collegial body and there's a meeting, whether it's purposeful or inadvertent, then we expect a tangible notice to go to the public. We expect minutes to be kept and those minutes to be recorded. So Matthew, Mark, and Luke can go to Taco Bell. They can do this under these facts. There's just a few steps they missed. First, they didn't give tangible notice to all Floridians about Taco Tuesday at that Taco Bell at that date and that time and that place, right? And they failed to keep minutes. Johnny got the burrito supreme. Alfred got the taco, hold the tomatoes. We all decided hold the tomatoes was a bad idea. They didn't take the minutes and they didn't record them. So this fact pattern can be okay if we do something ridiculous like that. But what had to be decided for the public policy behind Florida's Sunshine Law was this. Do we burden the public or do we burden the government? And the answer is clear from the case law. We burden the government. We do. Now, for example, if you get a position in Florida government, you'll probably be handed the Florida government and the Sunshine Law manual as part of your training. And that's a public document, of course, because the Sunshine Law. So you can read that manual. You'll see in there that it recommends if you're going to the restroom during the break of your collegial meeting, find out if there's any other member of the board in the restroom. If there is, wait till that member comes out so that you'll be in the restroom alone. This is the kind of advice we give the government. Is this a hefty burden, a ridiculous burden? Yes and yes. But that's what we want. We want accountability under Florida Sunshine Laws. We want transparency. We want to frustrate all evasive devices. Having a board meeting, your friend Joey's not voting the way you wanted to, so the chairman says, let's take a 10-minute break just for a bathroom recess, and then heads into the restroom with Joey. Joey, come on, I need your vote out there. And then heads back in. Right? We don't want that. We don't want that under Florida Sunshine Law. Can you do that under the federal government? Heck yeah. Matter of fact, you can brag about it. You can say, we're all part of the something something caucus. And we've been meeting all week and we've made the following decision. But not under Florida Sunshine Law. So yeah, the timing was part of it, but was not the decisive part of it. The decisive part of it was 3 members of the Vero Beach Council got together and could have discussed business, especially considering the timing. So that was why we get this outcome. And I'm losing track of the question. Oh, there was a question. Yes, go ahead. Same question. Okay, so did I answer it? Okay, you've got the answer. Okay, did I miss another? The questions are good. Keep the questions coming. It helps us flesh out the details. Yes, your question.
I just wanted to be clear, so ultimately, these 3 can never get together.
No, they can. They can. So the newspaper reads, Matthew, Mark, and Luke will be holding their usual Taco Tuesday this Tuesday at the Taco Bell on Highway 50 in Orlando from 3 p.m. to 3:45. The public is welcome to read the minutes. If you missed the meeting, go to blah, 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 blah. They can do that. Now, I hear what you're saying. McGinley, this sounds ridiculous. McGinley, you're on a crazy train. It's not me that's ridiculous and on a crazy train. It's Florida Sunshine Law that's ridiculous and is on a crazy train. But understand its ridiculous purpose. Understand it's ridiculous in favor of the citizen. It's ridiculous in favor of disclosure. Remember the pork chop gang. I'm sure the pork chop gang would have said, if any of them are still alive, which probably not, we were just drinking whiskey and playing cards. What a coincidence that we decided how to vote on legislation and what legislation gets voted on. We were just drinking whiskey and playing cards, says the pork chop gang. But it's the behavior of the pork chop gang that we were trying to outlaw. That was our purpose in the Sunshine Laws. So that's where we're coming from. 2 more hands. Who's first? Okay, go ahead.
So what if, say, Matthew is going to his old pal's house for a Christmas party,
Yeah.
and then Mark just so happened to get an invite, and he didn't know that Matthew was going to be there. Now that
Yeah.
they're there,
Yeah.
do they have to stay on opposite sides of the house?
You're almost reading me the bar exam question. And if you don't believe me, go to the website. The Florida Board of Bar Examiners maintains a website. They've got the old questions on there. You're almost reading it to me. So yeah, this was literally a question that would decide back then at that particular administration of the bar exam whether or not you got a license to practice law. So you want to understand this. The issues are that we're going to interpret the law in the light most favorable to the citizen. So yeah, Matthew, Mark, and Luke just at random find themselves at a Christmas party. You know, it's time for Matthew and Mark and Luke to politely excuse themselves from the party. Now that's terrible. I got elected to public office and now I have to limit the time I spend with my friends. Yeah, you do. That's terrible. Been elected to public office and I have to find out who's in the restroom first before I can go in there? Yeah, you do. We had to decide, should the public know the truth or should the elected official have an easier time going to the restroom? We chose that the public knows the truth. Did we make the wrong decision? That's up for you to decide and for the courts to decide. And the courts have undoubtedly, resoundingly decided no. By favoring the citizen, we've made the right decision. But there's a hand, and a hand. Yes. I got your answer in there? Okay. All right. Yes. Got it. Yes. Question.
So it says somewhere that this is necessary when there's reasonable foreseeability that something that's going to be brought forth is going to be discussed.
Yeah.
Why do I feel like reasonable foreseeability isn't cared about at all in sunshine law? Why would they include that particular terminology? Because that's what I think all of the class, or a lot of the class is thinking of.
Yeah. And I'm doing my best to dissuade them from that line of thought. Am I not? I mean, how much more animated can I be? I was jumping up and down yesterday. Maybe I'll do that today too. But yes, but I hear your question. And you've got some language from chapter 119 that sounds like I can use that language as a new exception to Florida Sunshine Law. And what all the case law has said is that we're not going to interpret that language as an exception. Maybe all the case law is wrong. You've only got about 45 years with the case law to overcome. So you can represent the government and you can say, I'm making this good faith argument that the last 45 years of case law are wrong and you should rule in my favor instead. Government does it all the time. Do they win? Almost never. Do they then pay attorney fees when they make these arguments? Almost always. But they do it all the time and they'll do it some more.
So to summarize like everything we've been talking about, forget about reasonable foreseeability.
Okay.
Don't hang out with your coworkers if you're in public government because you need to.
That's what the training manual says. Yeah. And you talk about reasonable foreseeability. Let me turn the question back to you. Whose burden will that be under the Sunshine Law? Must the citizen prove that it was reasonably foreseeable? Or must the government prove the negative, that it was not reasonably foreseeable? And the answer is that the government would have to prove the negative. In trying to meet the burden of proving a negative, which is always among the highest burdens, every fact that's at issue, we're going to interpret in the light most favorable to the citizen and in the light least favorable to the government. So turn back to Matthew, Mark, and Luke. Matthew, Mark, and Luke, isn't it true that after Monday's meeting, you decided to get together? Yes, it is. Okay? One way to interpret that fact is favorable to Matthew, Mark, and Luke. They're just a bunch of buddies who were getting together in between council meetings. The other way to interpret it is disfavorable to Matthew, Mark, and Luke, that they were having a pre-vote meeting. The law says how to interpret it. The law says as a matter of law, you're going to interpret that fact in favor of the citizen. So you got the most sympathetic Matthew and the most honest Mark and the most do-gooder Luke, and you've got a legal presumption that those facts are supposed to not go in their favor. And on top of that legal presumption, the burden of proof is theirs. So good luck with that, Matthew, Mark, and Luke.
So would that need to be proved beyond a reasonable doubt or pretty much 100%?
I don't see that phrase being used in the case law. So I can't answer yes that the legal standard is beyond a reasonable doubt because the case law doesn't reach into the criminal law and grab the criminal law standard and throw it into these cases. But the law does say these kinds of things, that we're going to interpret it most favorably to the public, that we're going to construe it to frustrate all evasive devices, and that it's got to be broadly construed to advance its remedial and protective purpose. So, hypothetically, a judge's written decision would go this way. The facts before me are in dispute. Matthew, Mark, and Luke argue that they've been lifelong friends. They always like to go to Taco Bell. They cannot disagree, however, that they arranged this particular meeting at the end of Monday's City Council meeting. Also, they cannot dispute the fact that this meeting would take place before Tuesday's council meeting. One way to interpret these facts is that Matthew, Mark, and Luke have arranged to have a meeting during the break between those two meetings. The law tells me to do this, quote, These facts, quote, should be construed as to frustrate all evasive devices, quote. The law also tells me to do this, quote, that these facts, quote, must be broadly construed to advance its remedial and protective purpose, end quote. I have no doubt that Matthew, Mark, and Luke are three great guys that just want to serve the state of Florida. Perhaps this sunshine law violation was merely inadvertent, but it was a violation nonetheless. Wherefore, it is adjudicated that the sunshine law has been violated. That's how that hypothetical ruling would go. And I hear what you're saying. Oh, poor government, you're saying. Poor government. They've got the right to tax us, an almost unlimited right, and an unlimited number of attorneys on their side, and an unlimited budget. And they've got to follow these burdensome laws. Oh, poor government. And I hear you saying that. And I respect that opinion. I'm just pointing out that when your elected officials pass these enabling statutes of the Sunshine Law, when your state court judges interpreted these Sunshine Laws, when the citizens of Florida amended the Constitution and the Sunshine Laws, those groups disagreed with you. Those groups didn't say, oh, poor government. They didn't say, oh, shucks, how do we let the government keep secrets from us, the citizens? Those groups didn't say, how do we empower the already rich and powerful government with even more powers? They said the opposite. And that's the point that I'm trying to make here today. I respect if you come to it from a different perspective, but know what the law is so that you can deal with it. Perhaps you're looking for disclosure, right? Do you have an uphill fight under Florida's sunshine laws? No. Perhaps you're looking for secrecy. Do you have an uphill fight under Florida's sunshine laws? Yes. That's what I need you to know. But I've missed all kinds of questions, have I not? Who's got a question for me? No? Okay. If you think of a question, just raise it. Happy to talk to you about it. I've lost track of what slide I'm on. Oh, we did Matthew, Mark, and Luke. Turn back to my case law quotes. Okay, here's a great one. What do you think of this hypothetical? What is the outcome here? Florida's Attorney General, in defending the constitutionality of a statute creating an exception to the Sunshine Law, concedes that the particular public necessity as stated in the law no longer exists. But the Attorney General properly pleads and proves not one, not two, but three other valid, important, critical necessities that advance the public welfare. So what has Florida's Attorney General done under this hypothetical? I've proven what the public welfare is, says Florida's Attorney General. I've proven not one, not two, but three instances of it. I've proven that they're valid, that they're important, that they're critical. And I've proven that this exception to the Sunshine Law advances not one, not two, but those three valid purposes. Yeah. The one mentioned in the statute. Okay, no, yeah. Forget about that one, says the Attorney General. Look at these three. Look at these. Is the law unconstitutional? Who will raise their hand and say, yes, under this hypothetical, the law is unconstitutional? Man, some of you catching on. I like this. Yes. Raise your hand if you want to be correct. Raise your hand if you want to say this hypothetical law is unconstitutional. Raise your hand if you see a sunshine law violation here, because there is. There is. Why? Why does this hypothetical spell out a sunshine law violation? Why would Florida's Attorney General lose here? Look what the Attorney General has done. She's proven not one, not two, but three other valid, important, and critical necessities. Your hand's up.
Only no other subject matter other than the.
Yes.
So that's the problem.
You nailed it. And before I even flip the slide, you nailed it. And here's the slide confirming that you nailed it. Because if it's on the slide, it's got to be true, right? Yeah, and you are correct. This is paraphrases what you said, does it not? The answer is yes, this law is unconstitutional. The Florida Attorney General's concession, remember the Attorney General conceded that the stated purpose in the text of this exception to the Sunshine Law was not good enough, was not valid. The Florida Attorney General's concession means that this statute violates Florida's Sunshine Law, violates Florida's Constitution on its face. Unique to laws creating sunshine exceptions is a facial requirement of a valid necessity stated on its face. A facially unconstitutional law is unenforceable. Remember the burden we gave to Florida's legislature when we amended the state constitution to add these sunshine laws that protect us as Florida citizens. We said, yeah, you can create new exceptions, but we're going to create for you procedural requirements that don't apply anywhere else. It's going to make it harder for you to create exceptions to Florida's sunshine laws. Now, I know you took Con Law 1, you studied federal con law. Some of these laws were created for one purpose, and then through creative litigating and creative arguing by the government, in some of those federal cases, the government managed to prove what they needed to prove for other reasons, right? Can't do that if you're trying to defend a sunshine law exception. If you've created a Florida statute that attempts to create an exception to Florida sunshine law, you've got to state on the face of that statute why. What's the public necessity that you're advancing here? And in my hypothetical, the Florida Attorney General's concession that that public necessity wasn't being advanced means that that exception to sunshine falls and becomes unconstitutional, regardless of whatever else might prop it up, because nothing else can prop it up because of this exception, this requirement, this facial textual requirement that applies to this type of law and this type of law alone. We're just about out of time. Our next lecture is on this same topic because we've got so much more to cover. And because it's appeared so many times on the Florida bar exam, and most of all because your working knowledge of these statutes empowers you to do something for a Florida resident that most residents of most states cannot do under their state constitution or under the federal constitution. This is a way to hold government accountable. This is a way to see documents, to attend meetings, to make copies, to make recordings. This is a valuable and powerful right that every Florida lawyer should know about. So we'll cover this again. Read the cases. We'll go over NCAA versus AP. We'll go over new. We'll go over the cases you see in your case book that I wrote for you. And we're going to learn these laws because of the importance. You've got a question?
So should we move on to chapter 3 or?
Oh, as the syllabus says, our next lecture also covers chapter 2. Yes, so far we've followed the syllabus and we'll continue to do so to the best of our ability. Yes, we're in Florida and there are hurricanes. Yes, we're in planet Earth and there is a pandemic. But barring the unforeseen, we're going to follow that syllabus. So next week, more sunshine. And until then, may God continue to bless us all. Thank you for being here tonight. Thank you. That's almost always going to be yeah, no exception.
They can be protected on the problem.
If they can meet the fact-finding exception, which is going to be part two. But under most examples of somebody trying to qualify to get fact-finding exception, more often than not, they're going to
I was just curious if there was some sort of protection, like for the president, he has protection so he can have private honest conversation.
Here you go. Let's talk about.
No, I'm talking about the federal.
Oh, okay, no, federal.
Right, how does the
Well, most of these
president have,
protections don't apply.
Right.
These are Florida
so
sunshine.
how does
These
the
are state
president
law
have
governments,
the ability to have an honest private conversation with his advisors?
right? I mean, there's so much
So there's
more
nothing-
defense behind us than Florida government. Yeah, yeah.
This seems weird, right? Like, how does the government still pull off these things when everything's out of control?
Very difficult. It's gotta be difficult on one side or the other.
Correct.
The all-powerful taxation government that has all the lawyers in the
Like,
world,
I
or
certainly-
the ordinary Joe who chose the government.
And I can certainly understand the ideas and everything behind the law.
Yeah.
It's just like, your mind doesn't understand that because everything you know about politics and the government says there has to be at least one shadow in the corner.
Right.
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 But they're just really good.
Well, the goal is that there is. The goal is that there is.
Thank you, Professor.
All right, good talking to you. Hey, what's up, man?
So I just wanted to make sure that, I just found out that now, I'm just gonna go on the website and do the attendance there.
Oh, dude, if you gotta put up with my lectures, you at least can put up for phone. Sign up for both. I didn't.
I just did it, yeah, I just did it right.
You did?
now.
Okay, cool.
Good, I just wanna make sure.
Yeah, no, I didn't hand it in yet, so.
Okay.
Yeah,
Okay.
Yeah, man, phew, get credit.
Thank you, Professor, I'll see you next week.
Thanks.